Chapter 11. Meet the Attorneys. I first met Sam Amorini at a meeting of Democratic committeemen for Norwood Park Township in the spring of 1977. He was introduced as a new precinct captain. Sam had lived in Norwich, Illinois since his high school days. Italian, short and robust, built like a fireplug. Squat. Hard. The neighborhood little guy, tough enough to play fullback with the older boys. He didn't know he was smaller than they were. The night we met, he was 28, had graduated from law school at Loyola University, and had been working as a public defender in the 3rd Municipal District of Des Plaines. He was a very persistent individual with inflexible ideas. A few months later, at a Norwood Park Township Lighting District meeting, our legal counsel resigned, having been appointed to a judgeship in the circuit courts, a position which would leave him no time to serve on our board. As a trustee, I asked the committeemen about a replacement, and one suggested Sam Amorini. According to the law, all our meetings had to have legal counsel in attendance. This is where I formed my casual relationship with Sam, rubbing shoulders in our committee work. From time to time, I called on him to help with small legal problems for some of my employees, traffic tickets for speeding or accidents. One time he handled a drug case for a family member of the owner of a gas station where PDM traded. The man's son and a friend, both dental students, were caught red-handed with marijuana, and, if convicted, they could not graduate from dental school. Amorini put the fix in. Each young man had to pay $400, supposedly siphoned to a judge for dismissal of the charges, plus Sam's fee. If a friend of Sam, or the friend of a friend, had a court case in the district where Sam worked, it was easy for him to get a dismissal. In December of 1978, after being hassled by the Des Plaines police and held at the station in regard to the missing Peast boy, I called Sam. I told him my situation, that my business attorney, Leroy Stevens, was to be out of town and my predicament was urgent. He was the only criminal lawyer I knew, however slightly. He was a defense attorney, yes, but, as it turned out, not for my kind of case. I never thought it would get so far out of hand. I wouldn't be charged with anything. It would be over any minute. The kid would go back home. Leroy Stevens had been handling PDM's legal work for several years. He had handled personal matters for my family as well. But I could tell from his initial visit to the Des Plaines police station that he knew nothing about criminal law. Otherwise, he would have immediately demanded to see the search warrant on which they were holding my car. He claimed that his first concern was to get me out of there. I couldn't argue with that. I had been illegally held for 9 hours for nothing more than going into a drugstore on business. But I wasn't his number one concern at the time. He had 2 buddies waiting outside in a car to go out of town on a fishing trip. If I hadn't been a good client, if I had been a stranger in search of help, he would have left me there for the weekend, showing up Monday with gratuitous apologies. On Thursday, December 15th, I met with Sam in his office after telling him the whole story about what had happened to me, retained him to handle the matter. All I wanted was for him to get a copy of the search warrant and confiscation inventory, which was supposed to be returned to the court within a reasonable time once the search was completed. He bragged a lot about working on the Patty Colombo case and how he felt it would be reversed. I guess that was to give me assurance of his experience in criminal cases. He did sound impressive, so I trusted him and put my faith in his ability to help me. I was sure mine was no more than a simple legal matter, but they had asked me about a missing boy, so maybe it was best to have this powerhouse of an attorney who could quash the matter quickly. I felt comfortable with him. After my arrest on December 22nd, the state attorney's office started spreading rumors that, since Amirani was a public defender, it was a conflict of interest for him to represent me before the bench in the 3rd Municipal District. That would have been true except for the fact that Sam had previously given notice that he was leaving that position for private practice, and he had had enough leave time and vacation time accrued so that he did not have to go back to that job. The state was merely trying to distract Amirani, to keep him busy straightening out personal matters when he needed to get his teeth into my case. Because of that confusion, the preoccupation of my attorney, my ignorance of the law, the horrendous charges lodged against me, the being jailed at Cermak, I didn't fully realize what was taking place in my life. At the hospital, I was kept strapped to a bed for 10 days with no knowledge of what was going on outside that room. During the few visits with Amirani and Stevens, I was never informed what was taking place. Every day I was sucked deeper into the darkness of guesswork and fear. Weeks went by without any information. Then on the 3rd day of January, I was brought from that dark, cold cell up to a room, and, without filling me in, Amirani asked me to meet with the sheriff and the state attorney's investigators, just to see if I could identify some pictures. Whatever I told them wouldn't be used against me, he said, and he would be at my side. So I sat and talked with them for some 4 hours. From that conversation would come a 10-page statement, not signed by me, but used against me later. No notes were taken, nothing was transcribed that day. There were 8 people in the room, often all talking at once, and how anyone could remember or even tell at the time what was said, or by whom, I'll never know. This confidential confab was used in court. During the week after the arraignment, I didn't like the way things were going. When he hired Robert Mata, I told Amirani to contact F. Lee Bailey and try to bring him into the case. He said he would, but a few days later when I asked about it, he told me, "John, you don't need F. Lee Bailey. Besides, I don't think he'd take the case. He is going through a divorce and he's got all kinds of problems. He's an alcoholic, and he's drunk most of the time." I still pressed the issue. I wanted them to contact Bailey and have him tell me himself that he didn't want my case. But that didn't happen. Amirani told me he was going to Boston on some other business and would talk to Bailey. I doubt that happened either. My situation was becoming bleak, and the thought of getting Bailey kept me from going under. Another thing on my mind during that time was my family. So much time had passed without any word from them. By the middle of January, I thought for sure they would want to know how I was doing. Amirani claimed to have talked to them on the phone. They were taking it very hard and didn't want to talk to me. "If you want to, go ahead and write to them, but don't give someone at the jail any letters to mail for you. There's a risk someone will sell them or take them to the state to use against you." So, when I wrote my family, I gave the letters to him to mail for me. No answers came, but I couldn't believe that my mother and sister would cut me off so completely. Then I started wondering about Amirani. I was already paranoid with all the things he was telling me that didn't make sense. I didn't believe anything anyone said anymore. The state was proclaiming to the press that I had voluntarily given 5 statements, and the press reported them to be confessions. To this date, I have never been shown a signed confession or even a statement about the charges that sent me to death row. A farce concocted by the state attorney's office to influence the public. By February, I'd had several strong arguments with both my attorneys. I fired them twice, but they paid no attention to what I said and made sure that news never went beyond those closed doors. I had no way of contacting anyone else. Even the social service worker assigned to me wouldn't do anything for me without Emirani's approval. I wasn't happy with his getting his way about everything. It seemed to me that nothing he was doing was working out. Any positive illusions I'd had about him were fading fast. But I was dead in the water. In February, we argued again about the insanity defense. He never explained my options, nor did he inform me of the full scope of an insanity plea. If you plead not guilty by reason of insanity, you're admitting that you committed the crime. Guilt is no longer an issue in a trial. I had been dead set against the plea, even without knowing that factor. I had told them that I did not kill those people, so why should I plead insanity? No. I entered a plea of not guilty, and that's what I wanted to stick with. The smooth-talking lawyers put me off, saying that I might not even go to trial. Once we got into court and had the judge strike down the validity of the search warrants, the case would be thrown out. I only had to trust them. Hell, who could I trust? I couldn't even talk to anyone else. The news was not good at the search warrant hearing. Judge Garippo allowed all 5 search warrants to stand, and I blame that on the inexperience of my attorneys. They should have been better prepared. Garippo was always searching for a way out of having to acknowledge any valid points put forward by my defense. Emirani and Mata should have done their homework and brought up cases to support their arguments. Instead, fast-thinking Kunkel brought up cases which only faintly compared with the issues in my case. The 3 cases Kunkel brought up indicated the testimony of eyewitnesses, while the warrants in my case supplied no eyewitnesses. That should have invalidated my comparison between those cases and mine. The warrants in my case were based on unreliable hearsay. But Garippo didn't want to handle the public pressure and ruled the search warrants valid. Emirani was so sure he had it in the bag, there wasn't even going to be a trial. But here I am on death row. Now he was selling me on his new 3-prong defense. The first prong was to be a not guilty plea, which I thought meant they would have to prove conclusively each charge against me. I wanted to be tried on each and every one of the murder charges. The state should have pounced on the opportunity. How could they lose? 33 shots at me. What did the state fear? Why their opposition to it? That is what I wanted all the time. I knew I didn't kill anyone. The state would not even be able to put me with them. Not a single charge could they prove. Emirani's second prong, he told me, was to try for a directed verdict of acquittal when the state couldn't prove its case. And the state couldn't. But even had he used it, the second prong would have failed because of the public pressure on an elected judge. Emirani had to realize that, but I didn't. I didn't know that both these prongs were merely sales pitches. Emirani never intended to use either of them. The third prong was the insanity defense. He knew I was against an insanity plea. To me, the idea was ridiculous. Let's stick to the first prong, I told them. I remember foolish using the word prong. It sounded obscene. Why would I want to go with an insanity defense when I knew I didn't kill anyone? when I didn't believe anyone could judge me to be insane. As early as March of 1979, Emirani had gotten several offers for book rights to the John Wayne Gacy story. He began telling me that everything we did from then on would be done to preserve the record. That was supposed to stop me from asking questions. I didn't even know what it meant. I was too tired to ask. When he first brought the book idea to me, I was in favor of it, knowing we needed money for a defense. One of the offers was supposedly for $6 million, but they wanted to start working on it while the investigation was still going on. Sam nixed that. He wasn't getting the kind of investigative reports he was looking for. Reports kept coming back with the information that others could have committed the murders, and he didn't want a journalist to get that information. It would have broken his control, his determination to go with the insanity defense. Some may say that this is all futile hindsight, and it is. But as I sit in my cell over the trial transcripts, I see so much that could have been done then. And I can see errors that should not have been made. Why did Emirani want Stevens off the case? It was more than the fact that he was a civil attorney. The main reason was that Stevens had known me a long time and was used to doing things my way. Had I told him to call F. Lee Bailey for me, he would have done it. Why Emirani brought in Bob Motta, I didn't understand at the time. A nice guy, but a puppet without a backbone. A lawyer afraid to interject his expertise into my case. Emirani had Motta in his hip pocket. He would never challenge Emirani's control. In July 1979, I had been sent to Cook County Hospital suffering from angina, and they wanted to keep me there for some tests. During that time, Emirani prepared and presented to the court the Joyner motion to pool the charges together and hold one trial. I told him no, I didn't want to stake my life. I asked him, if you're so sure of your defense, why not try it on one case? And if it works, use the same method on all the rest, or until the state gets tired. He had an answer for everything. John, if we don't join the cases together now, the state is going to bring the heads of all the victims in containers of formaldehyde and set them in front of the jury to stare at during the whole trial. It's an old trick to inflame the jury. Dumb me. What did I know? But I still told him I was against it. The Joyner motion was offered and granted without my agreement. I have reviewed the pre-trial transcripts where it says that Emirani came over to the table to ask me if I would agree to it. That never happened. Earlier that morning, I was taken from the Cook County Hospital back to Cermak. Emirani had not seen me for several days, and we didn't talk that day before the hearing got underway. When Emirani walked to the table and leaned over to talk to me, he asked me how I was feeling and if I was all done with the tests at the hospital. I nodded and told him I thought so. He then reapproached the bench. The judge had seen my nod and assumed I had agreed with the Joyner motion. I hadn't. During that month, I visited with my mother and sister for the first time since my arrest. It was only for a couple of hours, but we covered a lot of ground. I asked if they had received the letters I had given Emirani to mail for me. Karen said that a few came, but had been heavily censored with a black marking pen. When I asked why they didn't write, Karen said Sam advised them not to, because someone at the jail might steal the letters or turn them over to the state's attorney. He said he would keep them informed by telephone. How convincing he was. You can create more illusions with blind confidence than with a magician's wand, or 1,000 mirrors. Neither my mother nor sister cared for my lawyers, but they would go along with what I wanted. They weren't what I wanted, I said. I had wanted F. Lee Bailey, but Sam reported that he had talked to Bailey and he didn't want anything to do with the case. Later, I learned from a public defender's investigator who was in Amirani's office when a call came from Bailey that Bailey had indeed offered to enter the case as co-counsel. Amirani had refused Bailey's offer, telling him that it was erroneous to believe that I had even suggested soliciting his assistance. Any lawyer who would turn down the chance to work with an expert big league trial attorney has to have serious ego problems. Robert Mata was older than Amirani by 3 years. He agreed to become co-counsel after Sam told me he needed me for the arraignment. It was my understanding that he would be used only for that purpose, but once Amirani found out he could pull Mata's strings, he retained his services for the entire trial. Mata fell in line so he could stay on the case. He jumped at the chance to become part of a case so highly publicized. To me, he seemed to be very sharp in the courtroom. He had a knack for attacking witnesses, but lacked the experience to be in the big leagues. In the entire 14 months before the trial, I don't believe he contributed one idea. I wanted him to say just once, "I think I have a better approach," or, "John, from your viewpoint, how do you think it's going up to now?" But nothing. The prosecutors. Terry Sullivan was the first of 3 state attorneys I was to meet during my ordeal with the Cook County criminal justice system. My first encounter with him is described in Chapter 1. He stood by and watched my rights being violated and said nothing. Kosenchak threw me up against a wall, made me empty my pockets, and had me put in a cell. Sullivan didn't see it. The second time I saw him was in the Des Plaines courtroom on December 22nd, when I was formally charged with murder. I was told that he was outside the door during the so-called informal meeting at the hospital when I was asked to identify some pictures. He was afraid to show his face because he knew I didn't like him and might get up and leave. Maybe he was afraid of being confronted by my attorney about his conduct at the Des Plaines police station. In any case, his own guilt kept him out. Possibly a negative factor against me was the close friendship he shared with Amirani. I didn't know until much later that the two of them had worked closely together for the previous 5 years out of the same court building. Sullivan for the state, Amirani for the public defender. Had I known that in the beginning, Amirani would never have been my defense counsel. Over that period of time, they had to learn how each other operated, strategy, how the other approached a case. Influence there may have been, collusion there may have been. In any case, how can any attorney fight his best when he's fighting against a friend? Sullivan was smug and blustering, stepping on anyone who got in his way to make a name for himself. Holding press conferences and granting interviews was his forte. Even after the trial, he wasn't about to get out of the limelight. He violated the law by using material from the state attorney's office to write a book. He had it published, demeaning everyone else in the case, making it appear that if it hadn't been for him, there would have been no case. While serving in the state attorney's office, Sullivan was chief of the Drug Abuse Division. There he developed a drug abuse prevention program for first offenders and created and headed a special unit of undercover officers to investigate drug trafficking. During a particular investigation, a cache of confiscated cocaine disappeared. He quietly left the state attorney's office. Whether he was involved in the disappearance is not for me to say. I do know it was hushed up. The next prosecutor was Robert Egan, the youngest of the 3. Mild-mannered, he liked to deal in theories about the murders. Great imagination. He told a scenario at the beginning of my trial that should have gotten him an award for fantasy fiction. He had experience in the courtroom and knew what the jury enjoyed hearing. Prior to his duty in my case, he had handled 47 felony jury trials, of which 37 involved murder. The results: 42 convictions, 2 hung juries, 3 not guilty verdicts. He was a lion in court, confident, articulate, ready. A couple of times he rendered fantastic notions during interviews. One appeared in March 1982, front page Detective Magazine. One day recently, the prosecutor, Egan, got a terrifying letter from Gacy. It stated that he was prosecuted for the wrong thing, that he should have been convicted for running a graveyard without a license. Anytime Egan is ready, I would like for him to produce that letter. It wasn't written by me, nor have I had any contact with him whatever. Robert Egan has also left the state attorney's office for private practice in Chicago. The third member of the prosecution team was William Kunkel, Jr. He was chief counsel for the state attorney's office. During the pretrial hearing on motions, he came on like a bear. Emirani, the little giant, would take on the big bear, and they bucked heads until Garippo would remind them where they were. Kunkel got his way most of the time in those hearings. He had joined the state attorney's office in 1973, and in 1977 became supervisor of the felony trial courts and was appointed chief of the criminal division. This case was a sure stepping stone to his future. At age 38, it was time to make a name for himself. He used every trick in the book, every lie he could conceive. Garippo and Kunkel were made for each other. Kunkel found a weak-willed judge who would allow his unethical tactics. Garippo found an attorney who helped him do what he couldn't do for himself. Between them, they twisted laws until they no longer were anything resembling the laws on the books. I faced Kunkel's law and Garippo's law. Illinois statute law was forfeit. Kunkel had Egan's ability to sell fiction to a crowd. The courtroom is like a little theater. The lawyers are the starring actors. The jury compose the audience whose favor the lawyers seek to win. Just like in television and the movies, in the courtroom, the truth plays second fiddle to drama. Mesmerizing acting conceals lies. Kunkel had the gift of being able to arrest the jurors with gesture and voice. At times he would approach the jurors and nod his head as he lied, and I'll be damned if they didn't nod their heads in unison with him. His theatrics had more power than Emirani's objections. What he said was catchy. What he did with his face and hands was flashy. A great actor. Convincing. Captivating. William J. Kunkel had run twice for a circuit court judgeship. Both times he was turned away by the voters. When my trial was finished, and while his name was still vivid in the public mind, he ran again. He ostentatiously printed on his campaign literature, Chief Prosecutor of Mass Murderer John Wayne Gacy. He was riding the highest crest of fame and glory his life would probably ever attain. The voters dumped him again. The judge. Rounding out the cast of characters who played in my drama was none other than the Honorable Judge Louis B. Garippo. He had been on the bench for some 11 years, previously having served 10 years with the state attorney's office of Cook County. He was highly respected in the criminal courts by both prosecution and defense attorneys. But in this case, in an elective position, he was a victim of public pressure. A judge often must stand alone, steadfast, He must often lock his molars and make rulings contrary to public opinion. A judge, in the true sense, is a courageous giant, the apotheosis of virtue. Garippo failed the measure. A seasoned veteran of jurisprudence, he understood that the trial he was presiding over was rife with technical errors. There were so many times that some pause and reflection were warranted, but he ignored the importance of punctilious law. Look it up. It's flagrant through the trial recordings. Louis Garippo left the trial bench soon after my case ended in 1980 and entered private practice as a defense attorney.